Elaine Bean, why don't we just get started? Tell me what happens in general once somebody is declared competent. What happens next in the case?
Well, an important consideration in that is to understand that that competency finding does not mean that they are going to enter a guilty plea or something like that. In this case, what's happening is there's coming up an arraignment. So if you had an arraignment, that would be the time for any defendant to enter in a felony case a guilty plea or a not guilty plea. And so with a competency prior to arraignment and then coming up to that kind of hearing, that competency determination is really to decide, does this individual understand what's going on in the case? Do they understand the role of the judge? Do they understand the role of their own attorney? Do they understand the role of the prosecuting attorney? And after understanding all that, are they able to assist in their own defense? And so that would include entering a guilty or not guilty plea. If they don't understand the processes, then they wouldn't be able to properly enter a plea in that case.
Now, because a grand jury issued the indictment in this particular case, there is no preliminary hearing, which often the preliminary hearing gives us a kind of a preview as far as the evidence or potential witnesses, things like that. Explain why will there not be a preliminary hearing?
Well, the state has two options of routes to get a person charged in a felony case. And one of them is, and commonly used, especially in Bonneville County, we use the preliminary hearing route. And that means we charge someone by a criminal complaint. And then once they are seen by a judge, which is not the arraignment where they plead guilty or not guilty, it's called an initial appearance. Then at that time, they schedule a preliminary hearing. If someone's in custody, it has to be within 14 days, unless the defendant waives that time or there's extraordinary circumstances to continue it. If they're out of custody, 21 days, same kind of circumstance to continue it. The preliminary hearing would then be where the state, with the defendant and his or her attorney present, puts on evidence to show by probable cause that a defendant committed a crime. The defendant is then entitled, by doing the preliminary hearing route, to bring their own witnesses or have their attorney cross-examine the state's witnesses to try and show that there isn't probable cause to do the case. The alternative is to do that by grand jury. And with the grand jury, those are sealed proceedings where the state goes in front of the grand jury, which is kind of similar to a regular jury. You get a notification that you have jury duty. It's just for the grand jury instead of a jury trial, jury duty. And then those individuals listen to the state's evidence, and then they make a determination to find the charges true or not true. And if it is true, then they issue their indictment. So it's just two routes to get to the same end. And once a person has been found by probable cause to have committed that, both of those act as screening hearings. It's not a determination of guilt. It's just, is there enough evidence to go forward in the district court? Both of them function the same, just different routes. You can imagine in some cases where you might have sensitive victims or child sex cases where you don't want them to have to appear in front of a perpetrator, you could use the indictment route. But the danger of the indictment route is you can't use the testimony from the witnesses that testified in that grand jury proceeding in a later hearing should that witness become unavailable. So that's why we use the preliminary hearing route most of the time in Bonneville County, is so that if something were to happen later or somebody moves out of state or something like that, we could still use their testimony from the preliminary hearing.
That's interesting. I didn't know that. Let's talk about the death penalty. We know that prosecutors in the Daybell case are seeking the death penalty against Chad. They have not declared yet in Lori's case, simply, I believe, because it's been stayed. I mean, everything's been on hold. If they wish to declare the death penalty in her case, what happens?
So it's required that they file a written notice of their intent to seek the death penalty within 60 days from the date of arraignment. So that's that day where a person pleads guilty or not guilty. And that written notice has to list the aggravating factors, that's what they're called, statutory aggravating factors, that they would be using to seek the death penalty. So just because it's a murder one case, another case that you could seek the death penalty would be a kidnapping case. But in a murder one case, if you don't have any of those aggravating factors, then you probably wouldn't file that. But you can have more than one aggravating factor. And so what those aggravating factors are, some of them, I mean, there's quite a few, but if someone has previously been convicted of a homicide before of another person, then that would qualify them for the death penalty. If they, let's say someone set off a bomb and killed some people, and so in setting off that bomb, rather than just the people that it hurt, it posed a danger to lots of people. And so they created this risk to a great many people that could qualify them for the death penalty.
So basically they've got 60 days. The prosecutor has 60 days to declare.
Mhm.
Sometimes the prosecutor will declare it, but then later take it off the table, because can you take it off later, but you can't add it after 60 days?
That's correct. You can remove it or change it. So let's say that I said it caused a danger to a whole bunch of people, but then I want to say later, the way this crime was committed showed an utter disregard for human life. I could add that in or take the other one off once the notice is filed, but I can't just start it in 61 days with something that I didn't think of and didn't file the written notice.
Do you prepare differently as a prosecutor if it's death penalty or life in prison, or do you prepare on the charge? Does that make sense? You prepare to prosecute the charge rather than the penalty?
Well, certainly, the very first step is getting a conviction of the charge. So that's the first part. The jury has to find guilt on the charge, and then they go into a whole different process to evaluate the death penalty. So first you would focus on all that you needed to do to prepare for trial. Then you'd actually have a break and some time, and defense can have a mitigation expert. So they would bring in expert testimony about why the jury shouldn't do the death penalty, and the state would, have that opportunity to counter that mitigation expert. But certainly you got to get a conviction before you get to the death penalty phase of a proceeding.
When someone has been declared incompetent and then competent, and then the case moves along, is there a chance that later on they can be declared incompetent again?
Yeah, that can happen. So I'm just going to give you kind of a hypothetical situation. Let's say that someone has schizophrenia. We see that as a frequent diagnosis when someone is found incompetent. And then they take them, they get into Department of Health and Welfare custody, and they get treated for that. And sometimes that results from not being stabilized on their medication. And so once they can get regular medication and counseling and treatment and things like that, it's called restored to competency. Once they are restored to competency, then they, re-enter the criminal justice system as the case has been on hold during that process, and get going again. If that person then, for whatever reason, doesn't take their medication or maintain counseling and things like that, it's called decompensate. And so they could find themselves in a situation again where they need restoration again because of various factors. That's just one example of what could happen. But it can happen, particularly with different diagnoses. If the medication is very crucial and the medication is not being taken, then you can see someone decompensate.
So once somebody's arraigned, they plead guilty or not guilty. Let's say somebody pleads not guilty. What happens from there?
Normally, what happens is the court will schedule a pretrial conference and a jury trial setting. That's pretty standard after the arraignment. In cases that are more serious, it doesn't just have to be a murder case, but any particularly complicated case, the parties could ask for special settings or extra time because of anticipated consultation with expert witnesses or things like that. But it's still going to eventually should get scheduled for a pretrial and jury trial. If there were to be a resolution, they could vacate things and schedule a change of plea. That's with any case.
Yeah, but it's not like once somebody pleads that you're going to be having weekly hearings that are, televised and whatnot. It basically, the next step is get ready for the trial.
Yes. And in fact, when I have meetings with crime victims, we talk to them and say, usually at the beginning, when you're looking at that preliminary hearing stage up to arraignment, there's a lot that goes on right at the beginning.
Mhm.
And then there's a lot of waiting after that. And that's very normal. So you don't have weekly hearings. In fact, pretrials and jury trials in my court assignment right now are getting set in July. So if someone were arraigned today, the next time we would see them would be July.
Yeah. And then the trial comes. And after the trial, let's say somebody is found guilty of a particular crime. When do they then get sentenced?
Normally, the sentencing in any regular felony case would be approximately 8 weeks after the conviction date. So the guilty verdict, the change of plea, whatever happens. And that is in order for the Department of Corrections to prepare what's called a pre-sentence investigation. And that is a packet that tells a lot of information basically about a defendant. It'll talk about their childhood, it'll talk about their education, it'll talk about their job history, their family history, their substance abuse issues, mental health issues, and it'll give them a score from what's called a level of service index. We call it the LSI score, low, medium, or high risk to reoffend. And all that information and reports and police reports, witness statements, statements in favor of the defendant from people who want to write a letter on their behalf, all that is compiled into that pre-sentence report and distributed to the judge, the defense attorney, and the prosecutor. And that takes a really long time to prepare. So that's why we usually set them about 8 weeks out. In a case with a murder case, that can, by request of the parties, be longer.
And then does the judge determine the sentence or the jury?
Well, in a death penalty case, you have to have the jury make the finding for the death penalty. If it's not a death penalty case, then a judge would determine the sentence.
I see. So is that the only time that a jury decides the sentence if it's death penalty?
Correct.
In Idaho? Okay.
Correct.
So from what I recall, those PSIs are never public, right?
That's also correct. Yeah,
you never know what's in that packet.
Right. That's highly sensitive information, but that information does track the person pretty much for the rest of their life, because if they were to get something new, then the court could redistribute that original pre-sentence investigation as well as order a new one. So you can kind of see a glimpse. It's a snapshot of a person in time, basically, of how they're doing. And you can compare that later if they were to get a new charge.
Very good. Is there anything that you want to add, Elaine?
I think when we were talking a little bit just about preparing for trial and things like that, that's really a marathon for a prosecutor. That's when you perhaps get addicted to caffeine or, have the late nights.
Not a lot of sleep.
Like that. There's a lot of work that goes into preparing for trial. And in any case, and on a big case, it's just, you have hopefully a decent team of people. You're consulting with experts, you're reviewing reports and the facts so that you literally know those like the back of your hand and can stand up and tell a story to the jury about why they should agree with your side of the case. And it's just a lot of work that I don't think people realize goes into it, but it's also the reason us prosecutors are prosecutors, because this is really our favorite part of what we do, is going to trial. That's kind of like the cherry on top of everything. So.
Well, thank you very much, Elaine Bean, Bonneville County prosecuting attorney. Nothing to do with the Daybell case. She has not been involved in that. We just wanted a legal mind to kind of explain this to us. So I appreciate it.